You may have seen scary headlines saying the Supreme Court just wiped out location-based carry bans across America. Pause. Hold on, because that is not what happened. What actually happened is big, and it could affect where you carry next. But if you trust the wrong headline, you could walk into the wrong place with a gun and end up in serious legal trouble. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a major mistake the next time you carry. Hit that button now, because fast-moving gun law stories like this are exactly how good people get blindsided. Source. Here's what just happened. The Supreme Court did not issue some sweeping emergency order that erased every location-based carry ban in the country. Instead, the court took a regular case called Wolford v. Lopez. It agreed to review one narrow question, heard arguments on January 20th, 2026, and as of now, the court is deciding what to do. That is a huge difference. An emergency order is one thing. A normal case on the court's regular schedule is something else entirely. And the question in Wolford is not, can states ban carry anywhere? The real question is much narrower. It asks whether Hawaii can make it a crime for a licensed carry holder to bring a handgun onto private property open to the public, like a store or restaurant, unless the owner clearly says yes. Source. Source. Let me break that down for you in plain English. Most people hear location-based carry ban and think schools, parks, buses, courthouses, hospitals, churches, bars, and everything else on the list. But Wolford is not a full attack on every one of those places. The fight the justices agreed to hear is mainly about a default rule on private property that is open to the public. In other words, can a state flip the normal rule and say, no carry, unless the owner gave express permission first? That is the heart of the case. It is not a nationwide order, ending every so-called sensitive place restriction in one shot. Source. Now, this is where it gets interesting. Hawaii is not the only state that tried this kind of rule after Bruen. California also passed a law with a similar idea, and the lower courts have been fighting over how far states can go. Some lower courts have blocked parts of these laws. Some have allowed parts to stay in place. That's why you are seeing so much confusion online. People grab one lower court ruling, one headline or one oral argument clip, and then act like the whole country changed overnight. It didn't. Source. And here's the part nobody's talking about enough. Oral argument is not the same thing as a final ruling. Yes, some reporting said several conservative justices sounded skeptical of Hawaii's rule, but sounding skeptical in argument does not equal a final opinion on paper. Until the court releases that opinion, you do not have a new national carry rule. That means if your state still bans carry in certain places today, you cannot act like Wolford already saved you. Don't make that mistake. That mistake could cost you your permit, your gun rights, your money, and maybe your freedom. Source. First thing you need to know is this. Bruen did not say all location-based bans are automatically dead. That is one of the biggest myths in the gun world right now. In Bruen, the Supreme Court said the Second Amendment protects carrying a handgun in public for self-defense. But the court also made clear that some sensitive places can still be off limits. The opinion specifically pointed to examples like schools, government buildings, legislative assemblies, polling places, and courthouses. So if somebody tells you, Bruen means carry everywhere, that person is leaving out a very important part of the story. Source second, the real fight since Bruen has been over how far states can stretch that sensitive places idea. Can a state ban guns in a courthouse? That is easier to defend. Can it ban them in a school? Also easier to defend. But what about parks, beaches, restaurants that serve alcohol, public transit, libraries, museums, houses of worship, private businesses that never posted a no-gun sign? That is where the lawsuits exploded, and that is why the courts are, in the words of one recent analysis, all over the map. Source. Third, if you're hearing people say the Supreme Court already fixed New York, that is not right either. The Supreme Court did not hand down a merits ruling that wiped out New York's post-Bruen sensitive place laws nationwide. In Antoniuk versus James, the court first sent the case back after Rahimi in 2024. Then later reporting in 2025 said the justices declined to review New York's restrictions on the merits. So New York's law did not vanish because of some surprise national order. This is why I keep telling you that headline reading is dangerous. The details matter. Source. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when an officer asks about your firearm. Subscribe so you don't miss it, because knowing the law is great, but knowing what to say under pressure is a whole different skill. Now, let me explain why this matters to you in real life. Imagine you have a valid permit. You follow the law, you train, you stay out of trouble. You walk into a coffee shop, a grocery store, or a small family restaurant. Most people think, if there's no sign on the door, I'm good. But in a state using an express permission rule, that may not be true. The law may say no carry unless the owner clearly allowed it. That flips the normal expectation upside down, and that is exactly why Wolford matters so much. It is about the places you actually go in daily life. Source. But here's the crazy part. Even if the Supreme Court eventually strikes down Hawaii's rule, that still may not end every location-based carry ban across the nation. Why? Because the court could write a narrow opinion. It could say only that states cannot presume all private property open to the public is off limits unless the owner says yes. That would be important, very important. But it still would not automatically answer every fight over parks, transit, bars, schools, stadiums, churches, and government buildings. One recent analysis made that exact point. Even a decision in Wolford might not give much guidance on more typical sensitive place laws. Source. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's what most people get wrong. They think one Supreme Court case gives them a magic national carry map. It doesn't. Your actual risk depends on your state law, local enforcement, posted signs, permit status, and whether the place is public property, private property, or a place courts already treat as sensitive. That's why two people can both say, I read the same article, and one of them is still about to commit a crime. Pause. The article is not the law. The actual rule in your state is the law. Source. Source. Let me give you a hypothetical example to explain this. Say you live in a state that bans carry-on public transit. You hear online that the Supreme Court ended location bans,